question is, we know that we will die, and after time we will die. And my question is, I have written my will, and uh, during when I'm leaving, things have changed, and uh, in a simple way, can I update my will? Then, if I can update, how should I update the will that I've written already?
Thank you so much, Council. My name is Raymond, and I have quite a number of questions. But at, at the very beginning of the session, there were two conditions. One, you should be above 18, and I'm 23. Two, you also said that a person should have a sound mind. So my question is, at the time of writing the will, you as the executor or the advocate, how do you determine that the person is in a sound mind when he was writing the will? Then you also say that a will is a legal document. I want to know, because I feel like I want to write one. How much is it? Is it free of charge? Then the other thing is, I don't have a family lawyer friend, so I was requesting, Council Samson, you at least share your number with us just in case, because these things are quite many. And to be honest, we cannot resolve them in the next remaining minutes. Thank you so much.
Thank you, Council. My first question is, you talked about the witnesses, and you said maybe two. I want to know whether we can have more witnesses, and if it is so, is there a maximum? Can I bring 10 if I have trust issues? This one is out of curiosity. I have had the cases of families fighting with churches and all that. When you were talking about the beneficiaries, you talked about children and relatives and some other category. Are organizations like churches also beneficiaries? Thank you.
Yes. My name is Search Vincent, and what I want to ask is that I heard about stamp duty, and stamp duty is the tax that you pay for documents, for different documents to get valid. So do I need to pay stamp duty so that my will may get valid or not?
Thank you very much. I'm Evelyn. My question is, like, from the start as you were starting, you said privileged and unprivileged. I wanted to understand more what is how these two are different, like the definitions of the two. Then the other thing is, you talked about the written, like writing using my handwriting and then typing. There is a case whereby when you type a document and take it maybe like for editing or what, if they change anything, that document is totally different. So, and in most cases, you find that these documents that are taped, like in case someone presents a will that is taped, most cases in villages it is rejected because they think maybe it was maybe you taped what you felt is right, not what the person really intended. So how can that be overcome? Like how can these type things be made more trusted, more so in rural areas?
Thank you so much. My name is Nisingoma Justus. Let's ask, for instance, what if a man dies and he live like children, I can say, still little, still young, and they don't hear about people first speaking about the will. And when those people grow and they become men, I can say, and to the level of now saying now we need our land, we need to build, we need to marry, in that circumstance. But remember, when that person, when the father died, was still early, those people were still young, and they never heard about the will. and of course, each and everything was left in the hand of the mom. Do those people, or like those guys, those men, have the right to say now, let us share, because we are now old, we are in now the level of marrying or things of such kind? How can you try to clarify us about that? Thank you.
Thanks. My name is Innocent Samuel. My question is, in a situation, I've written my will, and the process of looking for those who can sign as witnesses, I die without them signing. How will they know that it is a true will? That's what I want to be clarified.
Pardon?
In the process of looking for those who can sign on that will
Witnesses.
like witnesses,
Yeah.
I die.
Aye. Okay.
Yes, that's what I want to clarify.
Sorry. My question is, I have 6 children. I make a will and I want to exclude one child. Is that will valid?
I didn't know that this topic was interesting to you as I discussed. However, I realized that I think it was an interesting topic, and I thank God for that. I have not gotten your names, but I've tried to write a sketch of the questions that have been asked. Sometimes also my handwriting confuses me. So I'll take some time as I. The first question was about oral issues said to be told to a person by the deceased, right? I think that was the first question. If I never made a will, right? And there was someone on my bedside, if the family can trust that person, that whatever they are saying could be true, such information can be followed. But where there is a will, you do not import in oral issues that he has told me, he has done what. Where there is a written will, we shall go by the will. We shall not go by the words that have been told to you. I don't know if I've answered that question. Secondly, the will must be in writing, just like we discussed. Then in case of absence of a will, I think I've mentioned that. Then if there is no will, the property or the estate shall be dealt with in a manner that they handle, or the law handles intestate estates. I told you that the law that governs estates are properties of persons that have passed on. So the law that governs those estates is the Succession Act, and that is the primary act or law, in addition to the Constitution of the Republic of Uganda. So in case of absence of a will, the law shall be followed in accordance to Section 23 of the Succession Act on how the estate will be dealt with. Then the other question was about secrecy of a will. And the categories of people that a testator should trust. People that do attest to a will, one should be your friends. This should be your friends, and you should trust them. Right? Because this is a document that is going to be enforced when you're no longer living. So if the testators, if the attestators are known people that can be trusted, then that means your estate is likely going to be prejudiced, because these witnesses can go and deal about with your will, since they know that there is a will. But it is important that when you write a will, that you tell a few people that you've written a will, even if they were not attestators, those that do witness your will. It is prudent that you can tell either your wife or your children or your family members that I wrote a will. But you may not disclose which people witnessed that will and which people have custody over that will. But it is important that your people know that there is a will and that they should expect a will to suffice in case you pass on. Another important issue that I never talked about, but I think it was somewhere from the questions that were asked, is that it is important that the people that do witness your will should not be beneficiaries in your estate. Are you getting that point? The people that do witness your will should not be beneficiaries under your estate. In case they are beneficiaries under your estate, that means the shares or the gifts that you give them in your will not be valid in law. So that will affect them instead. Are you getting that point? So avoid as much as you can for your wife not to witness your will, for your children not to witness your will. Witnesses should be people that are exclusively not interested in your estate, but should be trusted people. Among these, we can have elders of the church. These can be witnesses to your will. You can have advocates, just like me. I've handled issues concerning wills whereby they are contested. So once it was done in my presence or in any other advocate's presence, at least the advocate will ensure that your will is enforced. The others can be pastors and people that you do trust. Take the word trust. Then what happens to property that is not included in a will? Maybe I made the will earlier and I acquired more property. This property, if it is not included in the will be dealt with in accordance with the Succession Act in respect of properties that do fall under intestate estates. If you never distributed your properties in your will that you acquired after you made your will, these will be distributed according to the other percentages that we talked about. So that's how those properties that were not included in the will be dealt with. And in case you have the ability, you've made those properties, you've acquired those properties, and you would wish to include them in a will, the additional document that is made in addition to the original will is called a codicil. You make a codicil to show that there is an additional will. And if it is also okay with you, you can repeat the will and you call it the final or the last testament. Are we still together? But if you've not made a fresh will, the additional one, which includes the additional properties, will be called a codicil. And that one is a legal document as well, just like a will. Witnesses not reading the will. It is difficult to find someone who appends their signature on a document before they read or before they understand what are the contents of that document. Actually, it is very erroneous. But if you do have such kind of people, it is still very okay. The requirement of law is this should witness you as you append your signature, and you should witness them as they append their signature, but they must be aware that that is a will. They may not know the nitty-gritties of the will, but they must know that that is a will. Because one day in the future, these are the same people that will be required in case of any dispute in court to testify about the validity of that particular will. Then what happens to illiterate people who cannot read or write? You can approach professionals, or you can approach someone who has the capacity of helping you to write a will. But if a will of an illiterate is made in the presence of a professional, that will has to include a certificate of illiteracy. A certificate of illiteracy. This means that AB came to my chambers, I made a will on their behalf, but before they appended their signature, this will was read to them and they understood the contents that were in the English language before they appended their signature. And whoever translates that will should also append their signature. That is a requirement under the Illiterates Protection Act, that in case an illiterate is signing any document, that document has to be translated in the language that they fully understand and that they fully appreciate the details of that document before they appended their signature. However, still, the witnesses have to be present. I never talked about the language of a will. A will can be in several languages. A will can be in a language you're very comfortable with, or it can be in English. Most preferably, it should be in English, since our official language as a country is English, and also the official language of court is English. However, if it is made in a different language, not being English, prudent practice requires that this will has to be translated at Makerere School of Languages so that it conforms to the standards that are required in law. Can you orally change a will if you are an armed officer? Yes, as I was discussing privileged and unprivileged wills, I said a privileged will can either be oral or written, or partially oral or partially written. So while you are at the warfare or at the war front, you can do change your will, provided there are two witnesses that will testify about that. That is if you are a soldier at a warfare. But that does not apply to civilians or to unprivileged wills. And that's the difference between a privileged and unprivileged. A privileged can be both written and oral, or partially oral or written. But unprivileged must be written only. What happens if a beneficiary dies before the testator? How is that property dealt with, or if a share was given to a person who dies before the testator? If a beneficiary under will passes on before the testator, that means that property, you know, when you're distributing properties, you can specifically mention that I've given this piano to my daughter, right? But if it is in respect of shares, now let me contrast the two. If I've given that property, the piano, to my daughter, and she passes on, God forbid, before me, that piano will be dealt with in accordance with intestate properties, right? If it is also a share that was given to that child, it will also be dealt with in accordance with an intestate estate. But if my child had children as well, that property directly goes to my grandchildren. Are you getting the point? Because these are indirect beneficiaries. We have two categories of beneficiaries. There are those that are direct, recognized in law, and there are those that are indirect, depending on the circumstances of each case. So my grandchildren can benefit from my estate in case my son or my daughter passes on before I do pass on. But my will only come into effect upon my demise. So my will cannot be valid or cannot be enforced as I still live or survive. That moment will come when I pass on, that's when that will be enforced. Is it proper to disclose a share of a beneficiary in a will? You disclose to your children that I've given you this, and the wife, or I think it is dangerous. You can do it. The law does not give us details about that, but by practice, it could be dangerous. One, it can be dangerous to children if they see that one of them was given maybe a bigger share than the others, and that can turn out to be a war amongst them, right? It can also be dangerous to you, whereby these children would wish to acquire their properties as fast as possible. Because you've seen parents that live for 100 years and more than that. So this child will see, I know my land is there, and this man is still living, and in his will, himself disclosed to me that that is my property. So it can be also dangerous to the testator. You can face your fate before the day the Lord planned for you. So it is dangerous, but for transparency, sometimes you may do so if you do put measures that can limit the dangers of that. Best place to keep a will and how many copies? Best place to keep a will. You can keep your will with an advocate, with a priest, with a pastor. You can keep a will with a person who never witnessed it, right? Who never witnessed it, but you trust them. My last discussion was like there were some miscellaneous clauses whereby you can mention which particular persons have custody of your will. So in your will, you can also mention that I've given my will to so and so, but they must not be among the witnesses. How many copies? It should be at least. You can make one original, and photocopies can be made from that original. But if you can, if you can make more than one original, it is also okay, so long as it is the same will. It doesn't have any limit. The law doesn't provide any limit to the number of copies. What kind of people should be attestators? Attestators, these are the people that witness you as you sign your will and also as they sign. What kind of people? These are people that should be trusted. And these are people that should be of good standing. Mentioning expected money such as gratuity or ONSSF. Yes, you can mention that there is some money that I do expect, and you can distribute it in shares. Or if you are sure about the sum, then you can distribute it in figures. But it is very important that you distribute it in shares. Updating a will, I talked about that. That is a court seal. How do you determine a person of unsound mind? This is a very technical question. How do you determine a person of unsound mind? It is only medical practitioners that can determine a person of unsound mind, right? However, a person who is not in their right state of mind can also be seen ordinarily. Are you getting my point? However, if one can avail a certificate or documentary proof to show that the testator, at the time they executed their will, were not in unsound mind, that will shall be declared invalid and void. So you must have medical proof that this person, at the time and at the date of executing the will, was of unsound mind. but that's a medical issue. How much is the will? My contact, let me leave my contact. Professionally, I am not permitted to disclose how much a service is served to a particular client who approaches us. My contact is, if you can write it, my contact is 0703 31 21 43. 0703 31 21 43. Our chambers are at Rubaga Road, Access Building. The first floor, the law firm is called Serunjo Jimwebas and Company Advocates. Can we have more than 2 witnesses? And what's the maximum? The law doesn't give us how many. The minimum should be 2, but the law doesn't give us the maximum. So you can have as many as you can, but it is important that this will is kept in secrecy, and it is not, the details are not disclosed anyhow. So at least you should have a minimum of 2, but the maximum is not provided for in the law. Can a church be a beneficiary in a will? Yes, churches can be a beneficiary in a will, and you can distribute a part of your estate to a church, and the church will acquire a certificate of title. We have an office of the treasury here at CUC. They handle such issues in case you've bequeathed property to the church. Do I need to pay stamp duty for a will? No, you don't need to pay stamp duty for a will. It is not a legal requirement for you to pay stamp duty. I've given the difference between a privileged and unprivileged will, so I will not go into details of that again. Better proof that a typed will that people do not trust typed wills. Was that the question? Sorry? The reason that's why we have witnesses or attestators is for purposes of clarity in case disputes arise. So in case there is any dispute in respect of a will, this can be handled by court, and the attestators can come to court and witness about the validity of a will. So it being typed and it being handwritten, the form is still accepted, it being typed and it being handwritten. But avoid as much as you can to use a pencil. But if you've typed it, ensure that it conforms to the legal prerequisites. Sharing property to grown-up children if there is no will. Sorry? There are different questions. The last one was his. But sharing property, there was a gentleman that asked this question. Sharing property to grown-up children if there is no will. Yes, you can give out gifts to your children as you live. It's not supposed to be that you only give out property to your children upon your demise or in a will. You can give your children gifts while you still survive. I don't know if that was the question. Okay. In case the property was distributed and they were young and they were not mentioned in the will, is that a question? Where someone has made a will and there are some changes or missing issues in a will, right? That estate will be partially dealt with as an intestate estate. These children will be required to obtain a share from your estate. So in case you have distributed this property to other beneficiaries, and there are those that were not mentioned, and their children, your estate will be distributed in accordance to Section 23 of the Succession Act in respect of intestate estates. However, this will just be a guidance, will be just a guide as the estate will be distributed. I don't know if the answer is very clear. Because where you've not distributed their property to certain children, as a requirement of law, these children are supposed to have a share in your estate. So if you never mentioned them, and they are indeed your children, they have to acquire a certain share under the 75% that is given to children. Testator dies before the will is witnessed or attested to. That does not amount to a will because it was never attested to. So that is just a mere document. It's not a will. I intend to exclude one child. Yes, the law allows you to exclude any child of your choice because that is your wish, right? A will is an expression of your wishes that you would wish to take place at the time of your death. So you can exclude any child or any person from having a share in your estate, provided you've mentioned it specifically in your will, and this child will not claim, if at all, this child is above the age of 18. But if they are not above the age of 18, they must have a share in your estate because they are still minors. But if they're above the age of 18, you may exclude them. I want to thank you for listening to me. And I wish you a very good camp meeting. May God bless you.
Thank you very much. I want to repeat this